Hello, my name is Natalia Porsche, and I'm an attorney here in the United States. I practice immigration law in all 50 states in the US, and my primary areas are defense to deportation and visas. So in this video, I will address the cancellation of removal for non-LPRs, specifically factors, the hardship factors that an immigration judge will have to look at in order to decide your case, in order to decide whether you establish that you are eligible for cancellation of removal and you're eligible to receive a green card. Again, I'm not gonna speak about qualification that you have to be here for 10-year period. That information is in my in another video. But here I will specifically speak about the hardship factors, and we will look at case law. So the winning case here is the precedent which came from Board of Immigration Appeals, and it's the matter of Resinas. So this case is about a single woman who has been here in the United States living with her family, with all her family. She was originally from Mexico, and she had 4 United States citizen minor children who were born here in the US, all of them. And her parents also were LPRs, legal permanent residents. Again, this woman was undocumented, and I suspect she ended up in deportation proceeding for one reason or the other. The Board of Immigration Appeals, in its decision, does not address whether she had any criminal issues. Likely she did not, because any little criminal issue will be a problem in case of cancellation of removal for non-LPRs, right? Unlike LPRs, this is a little bit different issue, different case law. Okay, so in this case, the positive outcome out of this case was that Board of Immigration Appeal overruled immigration judge's decision that this lady, Ms. Resinas, did not establish that she is eligible, the extreme and unusual hardship factors, that she is eligible for cancellation of removal based on the fact that her the factors that she provided, the information that she provided, they were not strong enough, right? And what happened was the Board of Immigration Appeal overruled her decision, overruled the immigration judge's ruling. So why did Board of Immigration Appeal overrule the immigration judge? Well, first of all, Board of Immigration Appeals addressed 2 precedents, right? The one that existed before this case. So the Board of Immigration Appeals addressed matter of Monreal, and matter of Monreal is the BIA case, which was ruled in 2001. Which came down in 2001, and in this case, the Board of Immigration Appeals said that no, she's not eligible, this lady, single lady from Mexico, she's not eligible for cancellation of removal because the factors that her U.S. citizens' children will suffer, they're not good enough to establish the extreme and unusual hardship to them, right? That if they're going to return to Mexico, that they will suffer extreme and unusual hardship. Now, another case that BIA looked at, another precedent in this matter, was matter of Andazola. Okay, and that was BIA case, which also was rendered in 2002. So in this case, also it was a single Mexican lady. She had 2 kids, who was born here in the United States. So the BIA, they looked at the factors again, whether the fact and evidence that this Ms. Andazola provided to immigration judge, they established that that her children, her United States citizens' children, will suffer unusual and extreme hardship if she is removed to Mexico. Okay, so in matter of Andazola and matter of Monreal, they looked at the the details of how this lady was living in the United States. They look at factors such as, is she a single mom, right? If she's a single mom, who supports the family? Does she support her family? The father of the children, does he help at all with child support, with any clothing, food, or he is out of the picture? So those are some of the factors that BIA relied upon in deciding this present case, the one that matter of Racines, right? So they distinguish matter of Racines case from precedents. So in this precedents, matter of Andazol and matter of Monreal, BIA, they affirmed the ruling of immigration judge that these both Mexican ladies, they did not establish that their children, U.S. citizen children, will suffer extreme unusual circumstances. However, in this case, BIA said that yes, Ms. Racines did establish that. So that's the reason why I'm making this video, is to speak about these specific factors. And we are not addressing the medical condition of children. The medical, of course, will be very easy to establish extreme unusual hardship to U.S. citizen children or LPRs, family members. Why? Because that's the main factor, right? If the person is suffering from medical condition and that medical help is not available in the country of origin of the respondent, of course, yes, that's the extreme unusual hardship. However, those are the cases that I'm discussing here. Those are the precedents from BIA. Those cases, they do not address medical issues. They only address the financial issues and the circumstances, whether this respondent has a family, extended family in Mexico, whether respondent's family is all here in the United States, how respondent supports her family here in the United States. Right, so this matter of Racines is specifically a very important case. Because why? Because BIA also looked at her parents, because her parents, not just children, her parents, they were LPRs here in the United States, and she has been living here in the United States for a really long time. And also she supported not just her United States citizen children here financially, she had a business, but also she supported her LPR parents, right? So we have additional hardship here that BIA, Board of Immigration Appeal, looked at in deciding this case, in deciding that yes, this Ms. Racines, she did establish the extreme and unusual hardship to her relatives, to her U.S. citizen children and her parents, LPR parents. Now, how we distinguish this case, Racines, matter of Racines, from other cases, right, which had a negative ruling from BIA? Like I said, Ms. Racines had no family in Mexico. All her family were here in the United States. They were all LPRs, AUS, and US citizens. Now, she did have another children who were born in Mexico, but we're not going to discuss this in this video. So, first of all, she had no family there. She was the main source of income for her LPR parents and also her US citizen parents. Also, BIA looked at whether she had an extended family in the United States, in Mexico, right? So she had no family in Mexico whatsoever. All her family was here in the United States. So therefore, there would be no one, if she's a sole provider for the family, there would be no one who could take care of her children while she's working, because she is a sole provider. She is a single lady, right? She works all the time, so who would take care of her children? And also, very important factor was that her children spoke no Spanish. Like, they did not speak Spanish at all. So Board of Immigration Appeal also looked at that factor, because without speaking Spanish, and the children were already over 11 years old, how would they go? How would they be educated in Mexico, right? Because they don't speak the language, so there would be no one to educate them. So they're going to lose their education completely. So those factors are very important. So she had no family in Mexico. Children will suffer extreme unusual hardship because there will be no one to look after them while she is at work. They will receive no education, and they will have no grandparents who can help them when mom, let's say, is at work all the time and they speak no Spanish language whatsoever. So those are very important factors that BIA looked at. In addition, they looked at that the LPR parents are here in the United States and they will not be traveling to Mexico with her. So children will be left alone home while she's at work and she's a sole provider. Also, BIA looked at the fact that the father of the children was not on the picture at all. Like, he was not present in their lives. So therefore, he cannot even help. He couldn't even help. So this was the issue that I wanted to address in this video. I think it was very important because a lot of lawyers and a lot of people, they're on the assumption that well, if you don't have any medical condition, then you cannot establish a hardship. Well, that's wrong, because guess what, a lot of people don't have medical condition, and so those cases are very helpful in addition to show that not just medical condition can establish hardship, also financial conditions in such as no family back in Mexico or back in the country where the person is from, no language, right? No ability to speak the language, so no ability to find work. Let's say if this person doesn't speak the language, how this person will be able to find work, right? So those are the factors that BIA will look at. In this case, again, I will post it in my comments. It's called Inri Ariadna Angelica Gonzalez Resinas. So this is the name of the case. It was issued by BIA on September 19, 2002, and BIA really addressed, in this case, addressed the matter of Montreal, the matter of Andazola, the prime cases that BIA looks at comparing single, let's say comparing single parents, right, in both cases. So what's going on with this parent, what's going on with this parent, let's see how they function in daily life, who can help them with children. So I hope this video was helpful. If you would like to set up a consultation with me, with my office, give me a call. Our phone number is 228-229-7500. Thank you for watching this video. Have a great day. Goodbye.